Hi, students. Excited to have with me today Ryan Dibble, who is a deputy district attorney at the district attorney's office. And he's going to walk us through some key insights on what it means to prosecute. But before we get there, Ryan, do you mind sharing a little bit about yourself and your background?
Sure. Well, I grew up in the LA area. I went to USC for college. I got an accounting degree and a poli-sci degree there, and then stayed on for law school, graduated in 2005. Then after taking and passing the bar exam, my first job out of law school was to work for the LA County District Attorney's Office, where I've been working since. So almost 16 years now, and started out doing preliminary hearings in felony cases and misdemeanor trials. And then in LA County, it's a big office, so there's lots of opportunity from there. I started prosecuting felonies in Long Beach, jury trials, and then went downtown to continue prosecuting felony jury trials and preliminary hearings, and ultimately ended up in a division called Major Narcotics Division for 4.5 years. That division works a lot with wiretaps and Fourth Amendment issues, search warrants, and investigating major drug cartels, and also using wiretaps to investigate cold case murders. And then from there, I moved on to the Hardcore Gang Division, as it was known at the time, where I primarily handled murder cases involving a gang motive. And right now I'm in Long Beach branch courthouse handling homicides and other violent crimes. I'm actually in the middle of a murder trial right now. We're dark today, so happy to speak with you.
Great. Wow. And talk about keeping life interesting.
Yeah,
You've been
yeah.
all over the place. Just for the benefit of the class, because we haven't talked about preliminary hearings yet, do you mind just high level sharing a little bit about what the preliminary hearing process looks like?
Sure. So after somebody gets arrested for a crime, the first thing that the prosecutor does is file a case if there's enough evidence. And then within 10 court days of an arraignment, they have to proceed at a preliminary hearing. In reality, most defendants waive time, so it's not within 10 court days usually, but at that preliminary hearing, a judge listens to the evidence in the case, a very bare bones version of the evidence that is presented to establish probable cause to believe that the person committed the crime. It's like an indictment in federal court. We also have indictments in state court, but with local crime through the DA's office, most cases go through the preliminary hearing process where a judge listens to the evidence. And if they're held to answer at the preliminary hearing, then a jury trial date gets set.
Perfect. That's great. And you said something that I really want to touch on, which is if there is enough evidence, they will move to the next phase. And so that really touches on kind of one of the most important powers, let's call it, that we give prosecutors, which is prosecutorial discretion. Can you walk us through kind of your process on how you make calls on what to charge, who to charge, or even whether to charge?
Right. So usually it's a real candid conversation with the detective that comes in to present the case for filing. When I was working narcotics cases, these were sometimes very sophisticated cases that started with a wiretap, and we developed evidence together with the investigator with the wiretap up to know if there was enough for a conspiracy. Nowadays, where I'm prosecuting in Long Beach with violent crimes and homicides, I don't see the case until after the investigation has happened. So it varies from case to case, but ultimately what we're looking for is there enough evidence to not only for me to feel like there's enough evidence to show proof beyond a reasonable doubt, but is it likely that a jury will also see that evidence? How am I going to present this to a jury with admissible evidence in order to prove my case beyond a reasonable doubt? So a detective can come in and talk about all this great evidence. Well, we have to confirm it. We have to consider who our witnesses are, whether they're credible, are these people who are going to show up in court, and is it admissible evidence so that when a jury hears it, it's enough to get past trial. So we're always asking the tough questions. Sometimes we reject cases that are presented to us so that the detectives can further their investigation and make the case better before we go ahead and charge somebody and detain them pending trial potentially. without having a good case.
So, I mean, you highlighted something that's really interesting, which is, can you think of maybe a recent example or one from the past where you decided, nope, there's just not enough here, and
At
why? Yeah.
the filing stage.
Yes.
Oh, this one was a pretty easy one because the detectives actually came in and they were looking at us and saying, look, we kind of know where this is going to go. Could you take a look at this case and just give us the blessing, basically? It was a shooting, and by that I mean a blessing not to file.
Hmm.
There was a shooting where a victim was walked up upon very aggressively by some folks that were identifiable as gang members. And the victim in that incident actually was pistol whipped. And he, at the time, was illegally carrying his own gun. And when he had this aggressive person coming towards him with a gun and pistol whip him in defense of himself, he pulled the gun out and he shot the person who was coming towards him, and that person ultimately died. And so, we could have tried to file a murder case, but I didn't think, nobody would have thought that there'd be enough to overcome a self-defense claim, even though the person at the time wasn't really supposed to have a gun, to defend himself. So whenever there are issues like that, like self-defense, like a real insurmountable affirmative defense, we take a look at it and we'll officially reject the case because of the interest of justice or lack of evidence to prove a person guilty.
Great, thank you. And you mentioned detective. Obviously, there's what we call a prosecution team. So besides a detective, who else are you working with in building a case? And also, what the defense is looking at how your entire team operates, right? And trying to figure out if any one of them potentially violated the defendant's constitutional rights. So what is sort of the messaging you share with your prosecution team when you're getting ready?
I always just say, ask the right questions. I'm constantly, as far as our team is concerned, it's the police department, it's my office, DA investigators within my office, currently Long Beach Police Department, the agency that usually files cases that I prosecute now, our paralegals, and any other like labs where things get sent to for analysis. We're responsible for that. And you brought up the term prosecutorial team. It's important to be aware of who that is because under the disclosure rules and Brady and discovery, I am responsible for making sure that anything that the whole team is in possession of that's material under Brady and discoverable under California statutes gets disclosed. So the defense knows that. And so my general rule of thumb is I'm just always asking questions. What else is out there? In the trial that I'm in right now, I have cooperating witnesses who took leniency deals. And so all of the terms of their leniency deals are disclosable under a case called Giglio and obviously Brady. And so with experience, you just know, like, here are the sort of like the red flag areas where we need to make sure. And any case that gets particularly old in the system, I always make sure to run new witness rap sheets because we're always having to disclose criminal histories. And so those are typically the issues that come up. And obviously anything in the evidence that points to something that could be helpful for the defense, we have to turn that over.
Right. You mentioned Brady. So let's end there. Can you, just for the benefit of the class, walk us through what the Brady requirement is, and then what is your approach? How do you make sure you're fulfilling your Brady obligations?
So it's a multifaceted thing because Brady is fairly simple, and it came out that the prosecutor has a duty to disclose exculpatory material, exculpatory evidence to the defense. Now, that case begs a question, and that's an affirmative duty. I don't have to be asked in order to do that. The defense is entitled to it no matter what. Under California law, and I think the safer approach and the trend that it's going, the California law specifies that we turn over exculpatory information. the term material is left out, and what that does, it takes out the judgment call. If we see anything that could be used for a defense, either during the trial or could impeach a witness or could be favorable at sentencing, we turn it over. And it makes life a little easier because, you know, that way we just know that we should turn things over and it's not up to me to decide what is or what isn't material. Brady kind of got the ball rolling in that direction, but the California discovery rules are more friendly towards disclosure of evidence and information.
That's great. And if students are just generally interested in, you know, what the DA's office does, what a prosecutor does, any resources you would recommend just to get them started and interested?
Well, you know, the courts are open, so you can go to court and just go watch. I would say, you know, near USC, criminal courts building at Temple and Spring is just always packed with cases. The third floor is where preliminary hearings get heard, and the ninth floor is the long cause jury trial courts. They always have something real interesting going on. But other than that, you know, the DA's office website, I know they're hiring. They're always looking for interns, law clerks, and grade 1 deputy DAs too. So if anyone's close to taking the bar exam, consider it. It's a really fulfilling career. You know, you're always looking out to do the right thing, not just to seek convictions of people and protect the public, but also to do right by people's constitutional rights and make sure that we're prosecuting people the right way. So lots of different things to be proud of and working there. And I recommend at least doing a little research and considering it.
Great. Thank you, Ryan. Really appreciate all the insight you've provided just on kind of your day-to-day and also for taking a break from your murder trial and doing this with me. Really appreciate it.
I really appreciate it too. Thank you.